Hello, I'm Robert Howe of the law firm of Robert Howe PC, located in Brooklyn, New York. Right now we're going to talk about valid reasons for breach of a real estate contract. A typical real estate contract could contain about 30 paragraphs of representations of both the seller and the buyer and various contingencies. The seller, for instance, makes a variety of representations. One is that they own the property. Two is that they own it free and clear. Another representation might be the type of use that that property can be used for, i.e. a one-family or a two-family house. The buyer, on the other hand, makes representations such as he has sufficient cash to close on the transaction and that he will make a diligent application for a mortgage. A contract contains contingencies such as the contingency to get a mortgage or the contingency to sell my house in order to buy your house. Now, if any of those contingencies don't come true, generally the deal is canceled and the buyer will get their money back. However, as far as representations go, if any of the seller's representations are not true, either they really didn't own the property, they can't transfer it free and clear of any liens, loans, or judgments, then there may be an issue. The same goes for the buyer. If the buyer doesn't have sufficient cash or refuses to close on the day of closing, that may also present several legal problems. Now, if the seller declares the buyer in default, the seller may try to keep the deposit on the contract. If the buyer declares the seller in default, the buyer may be able to ask the court for specific performance, i.e., that the seller actually sell him the property. I'm Robert Howe of the law firm of Robert Howe PC, located in Brooklyn, New York. We've just been talking about valid reasons for breach of a real estate contract. If you need further information, you can contact me at the web, w.robert-howe.com. Thank you.